Good afternoon or good morning, depending on where you are joining us from today. My name is Matt Kissling, and I'm an associate with Thompson Hine, based in our office in Cleveland, Ohio. I'd like to welcome you to today's webinar on managing the 2021 workplace, vaccines, FFCRA, remote working, and more. I'm delighted to introduce two other colleagues that will be presenting with me today. First, Anthony McNamara, who's an associate in our Cincinnati office, and Debbie Brenneman, who's a partner in our Dayton office, both of whom are also in our labor and employment practice. For the next hour, we'll review the latest developments human resources and employment professionals are facing regarding vaccinations, COVID-19 protocols, and other related issues. There's been some guidance issued, but as you know, there are still many unknowns. We'll do our best to share what we should be aware of as we move forward today. Due to the large audience we have on this call and the amount of content we are presenting, we may only have a short time for Q&A at the end. We do encourage you to put your questions in the chat box on the right side of your screen, and we'll address them with whatever time we have remaining. We also encourage you to contact your Thompson Hine lawyer with any follow-up questions you may have after today's webinar. Thank you for your interest, and I'll now begin the webinar. And as one additional note, we will be sending the slides in today's recorded session out to everyone within 1 to 2 business days after we conclude today. So with that, I'm going to start things off today by talking about everyone's favorite topic, COVID-19 vaccination programs, specifically the EEOC and policy considerations as you can consider whether to put a vaccination policy in place. So as you may know, the EEOC issued updated guidance on December 16th, 2020, where they updated their technical assistance guidance on COVID-19 issues under federal employment laws. And with the updated guidance, they've intended to provide clarification on COVID-19 vaccination practices under a number of federal laws, including the Americans with Disabilities Act, Title VII of the Civil Rights Act, and the Genetic Information Non-Discrimination Act, or as we're going to refer to it today as GINA. So starting off with, let's talk about the ADA and COVID-19 vaccines. So what does the EEOC talk about here? At the outset, they make it clear that COVID-19 vaccines are not medical examinations under the Americans with Disabilities Act. And the reasoning is that by administering a vaccine, an employer is actually not seeking information about an employee's health status or impairments. So this would be similar to an employer-sponsored flu clinic or flu vaccine clinic or something along those lines. The EEOC also says that proof of vaccine requirements, where you have an employee obtain a vaccine outside of work and then present proof to you that they have done so, the EEOC says this is not a medical examination either. And the reasoning again is that requesting proof of receipt of a COVID-19 vaccination is not likely to elicit information about a disability. The thing to be aware of here is that the EEOC does caution against asking employees for any details about why an employee was not able to or did not receive a vaccine. In that situation, asking for those details, the EEOC says, is likely to elicit disability-related information and would be considered a medical examination, that's generally not permitted under the ADA. So next question is, what about pre-vaccine screenings? So again, the EEOC says that this is also likely to elicit disability-related information and would be subject to restrictions under the ADA. And the reasoning is that these screening questions seek medical details about individuals to determine if a COVID-19 vaccine can be safely administered, whether it's conducted by the employer directly or by a third party conducting the screening and administering the vaccinations on the employer's behalf. And the EEOC says these types of screening questions fall squarely within the scope of disability inquiries that are regulated and limited by the ADA. So if you want to ask about or conduct these pre-vaccine screenings, the EEOC says the employers do need to show that doing so is, as they put it, job-related and consistent with business necessity. And really the key inquiry here is, can you show that an employee who is not screened and then does not receive the vaccine poses a direct threat to the health or safety of themselves or your workforce? And the EEOC says the standard for this question is there a reasonable belief that a direct threat exists? And to have that reasonable belief, you would need to have facts or evidence to support a belief. So simply saying that we believe this individual poses a direct threat by not getting vaccinated is not going to be enough. You would need to have facts or evidence to back that up. So with that said, the EEOC does lay out a couple of exceptions to the restrictions on pre-vaccination inquiries. The first is if you have a voluntary employer program where a COVID-19 vaccine and the related pre-screening is offered on a voluntary basis. So employees are not required to do it, but they're provided the opportunity to do so if they choose to. And there also can be no consequences for an employee's refusal to either answer the pre-screening questions or obtain a COVID-19 vaccine. So if an employee refuses to answer the questions, you may decline to provide them the vaccination, but you can't otherwise take any sort of adverse action against that employee. You are still free to make them subject to other COVID-19 safety protocols, such as wearing a mask in the workplace or continuing social distancing and things along those lines, but there can really be no adverse consequences to the employee's job for refusal to go through the screening process or receive a vaccine. The other exception the EEOC identifies is if you have a truly, or as they put it, purely third-party administration of the COVID-19 vaccine. This is a program conducted by a third party with no connection to you as an employer. So it cannot be a company that you hire to conduct a vaccine clinic or administer the vaccines to your employees. Instead, it's a situation where an employee goes out and gets the vaccine on their own time and from their own providers, from a physician or another qualified provider who can administer the vaccine. And another key thing here is, as the employer, you also would not be able to request copies of any pre-screening surveys, since again, this is seeking details as to why a particular employee may or may not have received the COVID-19 vaccine. So if you have a purely third-party administration or a voluntary employer program, and the EEOC does identify these as exceptions to the limitations on the pre-screening inquiries under the ADA. The other big thing you need to consider in a COVID-19 vaccine program are reasonable accommodation obligations. So the EEOC squarely says that you are free to require COVID-19 vaccines for your employees as a condition to returning to the workplace, but you must still consider those reasonable accommodation issues. The EEOC considers the COVID-19 vaccine to be, as they put it, a safety-based qualification standard. And they say that similar to other qualification standards, you need to consider accommodations for disability under the ADA, accommodations for sincerely held religious beliefs under Title VII, and it's not written here, also accommodations for pregnancy or childbirth situations under the Pregnancy Non-Discrimination Act, since that law generally requires you to treat pregnant employees with respect to leave or accommodations equally as you would treat other employees facing similar situations. So from a disability perspective, one of the key things to remember is that if an employee is unable to receive a COVID-19 vaccine due to disability, you cannot automatically exclude them from the workplace. Instead, the EEOC lays out several steps that you need to follow. The first question is, do they pose a direct threat to the health or safety of themselves or your workforce by not being vaccinated? And the EEOC says there are really 4 factors you need to look at here: duration of risk, nature and severity of potential harm, likelihood of harm, and the imminence of the harm. The important thing to remember here is that this needs to be an individualized assessment for a particular employee who requests a disability accommodation. So you cannot make a generalization about each and every employee who is unable to receive a COVID-19 vaccine. Instead, you need to look at each case individually, because an employee who works on the assembly line or on the manufacturing floor, in close proximity to other workers, may pose a different risk or threat to their coworkers, as opposed to an employee who works in their own office, like myself here at Thompson Hine, working in my office, and unless I leave the office, not really having much direct exposure to other people in the workplace. So that's really kind of hammers home why it needs to be an individualized assessment, because the risk posed or the potential accommodation issue could differ depending on the employee that you're addressing it with. So then the second question, if you've identified that they would pose a direct threat, is can the threat be eliminated or reduced by a reasonable accommodation? And here, the EEOC says that you do need to engage in a flexible, interactive process, and again, it needs to be a case-by-case assessment. And this is really similar to any other disability accommodation situation where you're addressing it based on the employee at issue and the particular circumstances of the request. Interestingly enough, the EEOC does seem to embrace the concept of herd immunity for a COVID-19 vaccination, where they say, consideration may be the number of employees who have been vaccinated in the workplace and the amount of contact that employees have with others at work. And the EEOC says if after going through this interactive process, if no accommodation is possible, is the employee entitled to any leave or benefits under applicable law or company policy? So they say that you can lawfully exclude them from the workplace if you cannot identify a reasonable accommodation, but first you need to determine, do they have any available benefits or leave under policy or law before doing so. So in a similar stance, the EEOC talks about religious objections and the need to accommodate. And here, EEOC says that employers do need to consider, as they call it, sincerely held religious objections to COVID-19 vaccination. These objections are based on a sincerely held religious belief, practice, or observance of an employee. The important thing to remember here is that the religious objection is assumed to be sincerely held. So you as the employer must have an objective basis for questioning the religious objection to be able to request supporting information. So you need to have an objective basis for either questioning the religious basis for the objection or whether the employee actually is sincere in their belief and their objection on that religious basis. So mere disagreement with the employee's beliefs is not enough to be able to request a supporting information. Again, you need to have that objective basis supported by either documents or evidence to do so. And if you have a religious objection situation, the EEOC says you have a duty to accommodate unless doing so would impose an undue hardship. And so here it must be more than a de minimis cost, burden, or inconvenience. So if simply accommodating them would inconvenience you as an employer, the EEOC says that's not enough. You would still need to provide them with an accommodation. So it does need to be more than some minimal cost or burden in order to show an undue hardship. And a key thing to remember here is that this religious objections requirement or for accommodation does not extend to personal choice objections. So you as the employer do not have any obligation to accommodate employees who refuse a vaccine because of personal choice. So whether someone's anti-vaccination generally, they deny the existence of COVID-19, they're uncomfortable with the current emergency authorization status of the vaccines, or they don't feel that enough due diligence or tests or trials have been done for them to feel safe getting the vaccine, or if you're like me, you simply have a fear of needles or generally don't like going to the doctor or the hospital, and those are not sufficient reasons to object to a COVID-19 vaccination requirement. So the final area the EEOC talks about is with respect to GINA. So as you may know, GINA prohibits discrimination based on an employee's genetic information or their family history. Now, according to the EEOC, GINA is not implicated by the COVID-19 vaccine itself. As you may know, several of the vaccines are based on mRNA technology, but the EEOC says this does not implicate GINA because the CDC has made it clear that mRNA vaccines do not actually interact with human DNA. And because they don't interact with or otherwise alter human DNA, it does not implicate genetic information, and GINA would not apply to simply the vaccine itself. Similarly, GINA is not implicated by requiring or administering the vaccine. So if you want to put a mandatory policy in place, that in and of itself would not implicate GINA, and also requiring proof of vaccination alone would not implicate GINA. But GINA issues could arise if, again, going back to the pre-screening questions, if you seek family medical history or genetic test information as part of that pre-screening process, that's a situation where GINA would kick in and you would need to make sure you're following all the requirements that they lay out. The thing to remember is that the GINA issues would go away if an employee is required to get a vaccine, again, from their own physician, from an independent third party, because Gene is not implicated if the individual's physician asks them those questions. It only applies if you do so in the employment context. But again, another thing to remember is even if an employee goes to their own physician and undergoes the screening process, you as the employer should still not ask for documentation of those pre-screening questions or request details as to why an employee was not able to receive a COVID-19 vaccine. So obviously the EEOC lays out a number of pretty key and important legal considerations for COVID-19 vaccination programs. I also want to touch upon a few additional considerations for you as you're thinking about putting either a mandatory or a voluntary program in place. So the first question is obviously, should we make it mandatory or voluntary? And again, just to summarize what the EEOC says about this is that you are free to require COVID-19 vaccines, provided you take several steps. First, again, you consider accommodations for disability, sincerely held religious objections, or pregnancy or childbirth situations. Again, pre-screening questions, if you are going to ask them, need to be job related and consistent with business necessity. No inquiries can be made as to genetic testing or family medical history. And finally, you want to make sure that you have steps in place to protect the confidentiality of the vaccine administration and the pre-screening process in and of itself. So it's similar to other COVID-19 screening practices you may have in place, whether it's temperature screening or pre-shift questionnaires. It's important that those are all conducted confidentially, and because you need to protect the privacy of your employees and their medical information. So what are some other considerations for a mandatory vaccination program? The first thing to consider here is workers' compensation. So this really depends on the state you work in, but an employee illness due to a mandatory COVID-19 vaccine could support a workers' compensation claim. You've probably heard stories about folks who have gotten the vaccine and have had some pretty significant reactions to it. If they develop an illness because they received the COVID-19 vaccine, if it's under a mandatory policy, that could support a workers' comp claim, because the argument would be that it's receiving the vaccine is within the scope of employment. Another thing to consider is the time spent receiving the vaccine could also be covered by workers' compensation. So if you have an employee leave in the middle of their shift to go to a third-party clinic, and then they have to come back to work afterwards, the time they spend going to and from the workplace to the vaccination clinic would be considered as part of the scope of their employment. And if they're injured in that process, whether in a car accident or otherwise, that could give rise to a compensable workers' comp claim. Again, this depends on state law, since workers' comp law can differ depending on where you do business. But again, the argument would be that the mandatory vaccine program is within the scope of employment. Another thing to consider is wage and hour implications. So again, if you want to make vaccines mandatory, they should be paid for by you, the employer. So similar to a pre-employment physical or a pre-employment drug test, if you're requiring employees to receive it as part of their employment, you should either be paying for it directly, or if they go to a third party, reimbursing employees for the expense incurred with the test. This would apply even if it's potentially covered by your company insurance policy. If there's any sort of a copay that's required or any other costs of the employee, those should be things that should be paid for or reimbursed by you as the company. Another thing to think about is for your non-exempt folks, time spent receiving the vaccine is going to be considered compensable, because again, you're requiring them to do it. And another thing to think about is if you work in a state that is fun spread of hours, split shift, or call-in pay requirements, having someone come in during their off time or come in before a shift to get a COVID-19 vaccine could implicate these potential issues here. I'd like to point specifically to the call-in pay. If you do business in New York, you may know that if you call in an employee outside of their scheduled shift, or if you call them in for their shift and then require them to go home before they complete that scheduled shift, you are required to pay them a certain amount of call-in pay, which is at minimum 4 hours of time, or the full time of their work shift if it's shorter than 4 hours. So if you call them in to get a COVID vaccine and then have them go home, these unique state wage and hour requirements could kick in. Another thing to think about is if you are a unionized workforce. So the question here is, does your collective bargaining agreement provide express authorization for a vaccine mandate or a vaccine program? If the answer is no, and the union hasn't clearly waived their right to require bargaining on this issue, then you could have a duty to bargain with the union before implementing a mandatory program for union employees. So you may still be able to require it for non-union employees, but if you have a unionized workforce, you will need to consider the agreement, the CBA, before implementing a mandatory program. And then finally, something to think about is from an employee relations perspective. There are really a couple things to think about here is, first, if you're looking to put a mandatory program in place, how readily available is the vaccine due to CDC or state health guidelines? If you're like me working in Ohio, unless you're a frontline health worker or you fall within certain protected age categories, the likelihood of actually being able to get a COVID-19 vaccine in the near future is pretty remote. So, something to think about if you want to roll out a policy like this is it may not be possible for all of your employees to receive a vaccine immediately. So that's something you would need to take into consideration. Another thing to think about is, what if you have a high population of employees who do object to the vaccine based on personal choice? Again, you're not required to accommodate employees who are personally objecting to receiving a COVID vaccine. But if you have a high percentage of folks who are doing so, excluding them because of a personal choice, could tee up some sort of a disparate treatment claim based on a certain protected category, since requiring a COVID vaccine would be considered a term and condition of employment. And if it becomes apparent that certain protected race or gender categories or something along those lines are being disparately screened out from work because of their personal choice objections, that could tee up some sort of a discrimination claim. It's not saying it would go anywhere, but you could then be faced with the expense and annoyance of having to defend that kind of a claim in court or before the EEOC. Another thing to think about is you have this high number of people who object on personal choice. If you are accommodating other people based on disability, religion, or pregnancy, which you're required to do, that could actually undercut the argument that the vaccine is truly necessary for those other employees in your workforce. Where if you're allowing people to go without a vaccine because of disability or pregnancy or religious belief, that really raises the question: is the vaccine really necessary for your workforce as a whole? And that could be a question you would have to be faced with answering from folks who simply just don't want to get the vaccine. So on the flip side, let's talk about some considerations for voluntary programs. Again, this is a situation where you encourage, but you do not require employees to receive a COVID-19 vaccine. From a wage and hour perspective, this would mitigate the issues we discussed before related to vaccine administration, where employees are free to get the vaccine on their own time, but you're not requiring them to do so. From a workers' comp perspective, if the vaccine is purely voluntary, it would reduce the potential exposure if someone becomes ill because they received the vaccine. And again, the argument here would be that you're not requiring it and they're getting it on their own free time and it's their own voluntary choice. You as the employer would not be responsible for any sort of adverse effects that individual suffers because of the vaccine. And also, from the EEO or employee relations perspective, it would mitigate those issues related to accommodations and pre-screening questions, as well as again the potential for a disparate treatment claim or disparate impact claim, brought by people who have personal objections to receiving a vaccine. That would go out the window if it's a purely voluntary program. But of course, there are things you do need to consider on the flip side. Let's talk about OSHA or potential requirements from state health agencies. So if there's a situation where OSHA or their state equivalent would take the position that vaccines should be mandated for certain industries, this could require you to take a shift in your policy approach. The thing to note here is that if OSHA is going to do this, we would expect them to provide some advance notice and potentially go through the normal notification requirements under government regulations. So there would be some, some advance notice here. But if they do take that position, if you have currently a voluntary program in place, that could require you to shift gears and go to more of a mandatory approach. Other things to think about are some state laws. So in New York, actually right now, they have an assembly bill pending that would seek to require virtually all state residents to receive the COVID-19 vaccine under certain circumstances. I believe it would kick in if less than 70% of employees or individuals residing in the state end up voluntarily receiving the vaccine. Don't hold me to that, but there is some sort of a 70% threshold that serves as the trigger for the potential COVID-19 vaccine requirement. Again, we're not sure if Governor Cuomo is going to sign it, but this is something that has been put forward and is being considered. Another thing to look at is, state OSHA. I'd like to point to California, where they currently require employers to implement, as they put it, prevention programs for COVID-19. So the question here is, would a state like California expand those prevention programs to specifically require COVID-19 vaccines? If the answer is yes, then if you have operations in California, you would need to alter your approach for employees in that state. Another thing to look at is workers' compensation. So, having a non-vaccinated workforce would increase the risk of workplace COVID-19 spread, and demonstrated cases of COVID-19 outbreaks in the workplace could justify workers' compensation claims. And again, I point to California, where they've actually established a presumption that a COVID-19 illness amongst workers is work-related if you have 4 or more positive tests within a 14-day period. If that happens, employees file claims, then they have a rebuttable presumption that they got COVID-19 at work, and then you as the employer would be faced with the burden of disproving that before a state workers' compensation agency. So those are just things to consider for voluntary programs or policies. We think overall for any vaccination policy or program, a couple of key components that need to be in there. First, you need to clearly communicate your company's position on COVID-19 vaccines, whether it's mandatory or encouraged. You need to explain the procedure for employees to receive the vaccine, whether you're going to provide it directly or identify third parties where they can go receive it, as well as procedures for submission of proof, who are they going to send it to, payment for the vaccine or reimbursement, and any applicable deadlines for employees to get vaccinated or submit that proof. You should also discuss and outline what happens if an employee declines or is unable to receive a vaccine. What are they going to be able to still come to work, or are they going to be subject to other restrictions or other COVID-19 prevention practices or anything else? You should include EEOC protective provisions for disability accommodations or religious objections, as well as pregnancy-related situations. And you should also emphasize that all employee vaccine information, including objections to vaccination or requests for accommodation, will be kept confidential. And we do recommend that for any policy that you're thinking of rolling out, that you should have it reviewed by legal counsel to make sure you have everything squared away from a legal compliance perspective. So then very quickly, let's talk about vaccine administration. So some things you should think about here are, again, administrative options. Are you going to do an on-site vaccination clinic when you're able to do so and there's enough vaccines available to do that? Are you going to have off-site vaccination through a third party, or are you simply going to require employees to provide proof of vaccine? So as we discussed before, depending on which option you choose, that could have different legal implications and invoke different obligations for you as a company. Timing, consider waiting until a vaccine is more widely available to all employees under CDC and state guidelines. And I mentioned already a number of times the pre-screening requirements. You want to make sure that any questions comply with your obligations under the ADA and GINA. And you should establish a procedure for the confidential collection as well as retention of those pre-screening questions. And if you're contracting to a third party, something to think about is consider having an indemnification provision where if they don't maintain those pre-screening questions and they somehow are released, if an employee or someone else comes after you, have that third party be required to indemnify you for any claims you may face. So again, another thing from an administrative perspective, you need to consider accommodation procedures. And similar to any other reasonable accommodation situation, the important thing here is to develop uniform procedures for fielding, responding to, and documenting requests for accommodation, as well as providing guidelines for employees as well as in the folks who are fielding these requests for engaging in the interactive process. And kind of going along with any sort of policy rollout, it's important to prepare and train your HR staff and other program team members on your policy, the program, and the accommodation procedures. Because having these policies and programs in place aren't going to do you any good if the folks responsible for rolling them out don't know what they're supposed to be doing. Then finally, from an existing measures perspective, you should make it clear that a COVID-19 vaccine, receiving a vaccine, is not an excuse to disregard the other protective measures you have in place as an employer. So you should continue to implement and enforce your existing practices, including social distancing, you require them facial coverings, as well as your disinfection efforts, anything else you have in your COVID-19 prevention plan. And I will say, Thompson Hine, we are happy to assist you as you navigate through this process. We've actually developed a set of template COVID-19 vaccination policies that we'd be happy to work with you with to tailor to your specific business needs. So I know that's a lot of information on COVID-19 vaccines. I know we still have several other topics to cover today. Again, if you have any questions, between now and the end of the presentation, please feel free to enter them into the box or email me directly. Other than that, I'm going to turn it over to Anthony McNamara, and he's going to dive into the FFCRA in 2021 and what to expect now.
Thanks, Matt. Good afternoon, everyone, or I guess to Matt's earlier point, good morning to those of our clients that are out west. I have my pleasure to speak with you all today. I think that vaccine mandates and vaccine programs are certainly something that's on the forefront of everyone's mind right now. But with that said, there are plenty of other items that we need to keep in mind as we enter the new year. One of which being, what's happened to the Families First Coronavirus Response Act now that we've entered 2021. And I'll make a point just to note that, we will only be talking about the FFCRA and its implications in the new year. Other states that have enacted laws providing COVID-19 relief or which may have expanded what the FFCRA provided, those are kind of outside the scope of this, but I'm certainly happy to discuss with any of you one-on-one how those laws might apply moving forward. So we'll start with just a short overview of the FFCRA. I know that we've had this ingrained in our mind for some time, but as you'll all recall, under the FFCRA, which went into effect last April 1st, I believe, covered employers are required to provide a certain amount of paid sick leave and paid emergency family medical leave, or really what's kind of a paid child care leave when you look at it to various eligible employees. FFCRA only applies to employers with fewer than 500 employees. On the emergency paid sick leave provision, that's 2 weeks of leave up to 80 hours. On the paid child care portion, the first 2 weeks are unpaid, although there is kind of an interconnection with the paid sick leave that's available, but then another 10 weeks paid for qualifying reasons under the EFMLA. So that ended at the end of last year. So the question's been, what does that mean for us moving forward? And we've recently got some guidance on this from the federal government. So first, we had the Consolidated Appropriations Act for 2021, which Congress passed just before Christmas on December 21st, in which President Trump signed into law on December 27th. That provides an optional extension on the emergency paid sick leave and the emergency child care leave and associated tax credits that are available for employers who decide to provide that leave. And then we've also recently started seeing some DOL, some Department of Labor guidance on how this should be interpreted. We do expect to see some more of that here in the near future. As it relates to the budget bill, the Consolidated Appropriations Act, under that act, the FFCRA was not in and of itself extended. So that mandatory leave still expired on December 31st of last year. That said, beginning January 1st of this year, covered employers can voluntarily decide to continue to provide either one or both, as we read the statute, of the paid sick leave or the paid child care leave for the same reasons that were available under FFCRA. But really, the carrot that the government has dangled is you have the option to provide this leave, and if you do, you are still entitled to use the payroll tax credits associated with that leave for any leave that's taken between now and the end of March. Once we hit April 1 of this year, any additional leave that's provided is really on the employer. There won't be any tax credits available for that. So how it relates to the amount of leave that could be available to employees, this is something that is not entirely clear from the language of the bill. We are looking to receive guidance from the Department of Labor on this soon, but from what we do see, the extension doesn't appear to create a new bucket of emergency paid sick leave. So it doesn't provide an entirely new set of 80 hours of paid sick leave as was provided under FFCRA. So what it does is really carry over anything that may have not been used by an employee in 2020. So if an employee used all of their available sick leave before the end of the year, they're not entitled to any additional leave, even if the employer decides to extend the program, and there wouldn't be any tax credits available for leave provided to those employees who had already exhausted what was available. On the EFMLA, if you want to go back real quick, on the EFMLA piece, it's a little different. As you'll know, under the FMLA, so really let me back up. What the FFCRA did with relation to FMLA is amend that statute to provide new reasons related to child care that you can obtain FMLA. And so depending on how an employer calculates their FMLA leave year, for instance, on a rolling basis as opposed to a calendar year, there could be some instances in which, the leave year may reset between now and March 31st, and an employee could qualify for an entirely new period of available EFMLA. So this is something that employers should take into consideration when deciding whether or not to provide the EFMLA component. It does appear that an employer can decide to provide sick leave but not the FMLA component. It doesn't seem to be a package deal. So that's something that should be considered. That's something that we can certainly discuss with you privately to see how that may be affected. Now we're ready for the next slide. So the other component that we've received is some recent guidance from the DOL. This also came at the end of last year when the DOL updated its frequently asked questions regarding the FFCRA on its website. And really what the DOL has done is simply, one, confirm that, providing additional FFCRA leave now in 2021 isn't something that employers are required to do. It's merely discretionary. But, obviously, if you do decide to do it, there are some tax benefits to doing so. And then alternatively, the DOL simply reiterated that it will continue to enforce the FFCRA and prosecute violations that occurred during the FFCRA's enforceable period, so between April and December of last year, through the expiration of the statute of limitations for any such claim, which is generally 2 years, 3 years for a willful violation. So, it also caps when it would take complaints in for any complaints made through the end of last year. So that's what we've heard from the DOL so far. We do anticipate getting some more guidance from them, including how the different, and from the IRS too, on how the different tax issues may apply, how the EFMLA piece may be affected by the new provisions. Once we have those, we'll know better how this leave can be administered moving forward. So again, it's been a pleasure speaking with everyone. And here's my contact information. If any of you have any questions, I'm happy to talk with you offline. But for now, we will move on to Debbie and her piece and the additional information that she has.
Great, thanks, Anthony. And also, I will say it's a pleasure to speak with all of you. Thanks for your interest and thanks for joining us. And with that being said, fasten your seatbelts. I have a potpourri of 2021 updates and forecasts. So we're going to go through a lot of information in the remaining 20 minutes. And I want to start with just updating you on the latest CDC guidance with regard to workplace safety. Next screen. On December 31st, 2020, instead of preparing to celebrate the new year, the CDC was hard at work updating its guidance on workplace safety related to COVID-19 issues. This updated guidance did a few things. It expanded the guidance on health checks, regardless of whether those are conducted in person or virtually. It added a section on testing considerations. It addressed and identified shortened quarantine options for employers. We'll talk about those, and clarified that all workers should wear masks. We've had lots of questions, especially from employers in the manufacturing setting where it's not necessarily conducive to their employment, whether there are exceptions, and this latest CDC guidance said, nope, everybody should be wearing masks at work. Next screen. Drilling down into some of the information that it provides with regard to testing, the CDC guidance now does urge employers to consider and implement some type of approach to testing of individuals in the workplace. And they laid out a number of things that could be. It can be initial testing of all employees entering the workplace. I don't read that to mean every time they enter the workplace, but if you're just starting operations back up, or maybe one initial baseline test. It suggests periodic testing at regular intervals, but you certainly would want to make sure if you're doing that you are being consistent in that type of application. So that may be regular intervals across the whole employment spectrum. It could be regular intervals in high population, high density departments within there, but just make sure you're thoughtful and consistent in how you do that. The CDC also suggested targeted testing of new workers or workers who are returning after a prolonged absence, maybe a medical absence, maybe they've been on vacation, something like that. And certainly the CDC urges a combination of approaches. So take a look at these. If they're not, if you don't have some testing policies in your workplace, the CDC is urging that you do consider that. Next screen. Interestingly, the CDC did issue some shortened quarantine options for employers. As I'm sure everybody is aware, the recommendation had been 14 days, and that was based upon the estimates of the upper bounds of the COVID-19 incubation period. The shortened quarantine options are based upon some scientific studies by the CDC personnel that are outlined in the guidance, and I won't bore you with the empirical evidence, but here's what the CDC says that you can consider now. Quarantine can end on day 10 without testing if no symptoms have been reported during daily monitoring. Also, quarantine can end on day 7 with a negative test and no symptoms during daily monitoring. The CDC's thought process on this, as it's set forth, is its belief that this will strengthen compliance, that if there are shortened options, that folks may be more willing to comply with those. But they did say they can continue to believe that 14 days is the best option, but you are allowed under the guidance to go to the 7 or 10 day options. Next screen. With regard to the expanded guidance on workplace safety, the CDC spends some time talking about employee health checks and how those should be conducted. It sets forth guidance with regard to virtual health checks and suggests some electronic monitoring systems so that employees can kind of check in and provide the information remotely before they arrive at the workplace. For in-person health checks, the CDC has a number of different recommendations. First, it suggests that you may utilize social distancing during the screening. So if you are an employer that has in-person screening, but the employee is the one taking his or her own temperature and the screener is just observing them for other signs of illnesses, then make sure you're utilizing social distancing and other, masks. And that's all the PPE that's required. If the screener is actually taking the employee's temperature, the CDC suggests that you have some type of barrier or partition between the screener and the employee. So that could be plexiglass or glass or some type of divider that the screener then reaches around the divider, keeping their face behind the screen at all times. The CDC suggests that the screener wear gloves and that the screener change those gloves and wash hands in between each screening activity, so in between every employee. And of course, the CDC requires, or the guidance suggests that if you're using contact thermometers, like a forehead scan or something like that, that those should be cleaned and disinfected after each and every use. Next screen. Remote working, some employers have resumed operations, but for most of us, our offices and workplaces don't look exactly the same. Remote work continues to be commonplace, and it looks like it's going to be around on a long-term basis even after the pandemic subsides. Next screen. A PricewaterhouseCoopers study that was released just earlier this week shows that, prompted by the COVID model, a lot of companies are heading toward a hybrid workplace. Many are intending to have a large number of office employees rotate in and out of offices configured for shared spaces on an ongoing basis. Next screen. According to the study, remote working has been deemed a success by study participants. 83% of employers say that the shift to remote work has been successful for the company, and more than half of the executives who were surveyed says that employee productivity has actually improved in the remote environment. Next screen. With regard to the future and how things look, certainly employers, fewer than 1 in 5 executives say they want to go back to exactly how things were pre-pandemic. But how some office time does remain important to virtually all of the executives surveyed. More than 2/3 of executives say a typical employee should be in the office at least 3 days a week to maintain a distinct company culture. On the flip side, over half of employees want to work remotely 3 days a week or more. So a little bit of a distinction and perception there. So we'll see how that plays out. But 65% of executives believe that office time is very important to increasing employee productivity. And over half also consider the office very important for employee collaboration, providing space to meet with clients and promoting that company culture. Next screen. With the ongoing remote work environment that we face, the new normal brings new legal challenges for employers, things that you should be thoughtful and thinking through. We've had entire seminars on unique trade secret issues that arise in this new remote working world. Certainly one component of protecting trade secret information is showing that you have taken reasonable steps to protect the integrity of that information. And having workers work remotely causes a threat to that. Employers don't know how documents and information are being treated. Are they left laying around the employee's home? Are employees off in coffee shops, Starbucks, et cetera, doing the work and having documents pulled up on the screen? Is there increased use of personal devices and the increased threat of transfer of information and documents? So trade secret information issues alone require really a revisiting of trade secret policies, updating of those policies, and certainly reminding employees of their obligations as they work in this new normal environment. There are also privacy and security concerns. Employers clearly don't have the same controls over an employee's home Wi-Fi network or public networks that they may be using. We have seen increased instances of hacking. So again, it's important that you make sure that your privacy and security policies are up to date and address the remote working environment. You might require your employees to use a VPN. You might increase password protection, go to a two-factor authentication system, require password protection for home Wi-Fi networks. You might even consider encrypting hard drives, so pay attention to that. And remote working causes state-specific payroll issues. Your employees, even if they're just working from their house, may be in a different state than your location is. Or we've seen many instances where folks say, well, hey, this is a great time for us to, my partner and I, to travel around a bit and work from Airbnbs around the country. Well, you need to know that, because where the employee is actually working may trigger state-specific payroll issues, such as rest requirements, payroll tax issues, information that needs to appear on pay stubs, payday frequency requirements, and paycheck delivery requirements. So you need to have a handle on where your employees are working, are they moving around, and make sure you're identifying any specific issues that may arise as a result of those various remote locations. Next screen. I'm going to spend a few minutes now talking about the litigation landscape as we see it shaping up for 2021, and lots of things for you to keep an eye on there. Next screen. With regard to 2020 and disputes with employers, terminations understandably topped the list of COVID-19 related litigation in 2020. It was about 3/4 of the disputes with employers, and not surprisingly, given the number of terminations that did occur. The next most frequent disputes were related to safety and compliance issues, where employees raised concerns that employers were not taking sufficient steps with regard to workplace safety or compliance with COVID-19 requirements and guidance, and retaliation issues. And those type of complaints are likely not going away even as we bring people back to work. So you need to be mindful if someone raises a concern about what is or is not occurring in the workplace. Could even go back to the vaccine question, whether you're mandating or encouraging that. You may have employees continue to raise issues about what you are or are not doing. And just as if someone was coming forward with a discrimination or a harassment complaint, you should take those concerns seriously. You should make sure you talk to the employee, have a process in place for reviewing it. If there are steps required to be taken, take them. If there are not steps required to be taken, communicate to the employee why no additional steps were required, and make sure those employees are sort of on that watch list, that if they are subject to termination or some disciplinary action in the next 6 months or year, make sure that there is a next layer, a next level review of that decision to minimize any risk that that action is taken in retaliation for them having raised concerns. Next screen. In 2020, we saw a significant decrease in the number of harassment and discrimination claims, and really that's not a surprise. I mean, first of all, there was a huge decline in actual human interaction, so that certainly lessens the risk. The Trump administration had very business-friendly policies, so the EEOC and the DOL really did not have as many enforcement actions as we had seen in previous administrations, but not to worry. We do expect that to change when the Biden administration takes over. We do expect that those agencies will be very aggressively enforcing and expanding workplace EEO laws, so likely see an increase in that activity in 2021. Next screen. With regard to wage and hour claims, those claims certainly have become the darling of the plaintiff's bar in recent years. That was no change in 2020. Plaintiffs' lawyers actually won conditional certification at record high rates last year. And it would seem likely that the risk of wage and hour claims is only exacerbated with the remote work routine brought on by the pandemic. We have an extraordinary number of non-exempt employees who are now working from home, and timekeeping procedures may not have kept up with that trend. Non-exempt employees may be working non-traditional hours as they also juggle remote schooling and other obligations. They may have a flex time arrangement. So employers really need to make sure that their timekeeping procedures are solid, that they are communicating the timekeeping procedures to their employees who are working remotely, and train your managers to look out for warning signs. You know, if an employee always records, they're working remotely and they always record 8 to 12 and 1 to 5 as their hours, they may just be tracking their schedule rather than actually recording hours. Remind managers, employee, and supervisors to look for things like emails outside of expected hours. Of course, if there is that activity outside of usual work hours, you need to pay it, but you can remind that employee that they need to adhere to your hours or the maximum hours, and that overtime must be approved in advance, but make sure you're compliant with wage and hour issues. Next screen. Also, WARN Act cases brought on by COVID have gotten a green light, and there's some renewed cause for concern for potential liability for mass layoffs. Many employers thought perhaps that were forced to conduct layoffs pretty quickly and without the traditional notice required under WARN if they're covered by WARN. And many employers, and frankly us, really thought that perhaps the safe havens would excuse a lack of notice, the safe havens being either natural disaster or unforeseen business circumstances. But a Florida federal case, which was really viewed as a test case for this issue, just got a ruling from the judge that denied the attempt to have it dismissed under the WARN Act under these exceptions. The judge outright rejected the natural disaster defense, saying that this may have been an indirect result of a natural disaster, but not a direct result, and said that more discovery was necessary before the judge could conclude whether the unforeseeable business circumstances defense would apply and whether the notice that was provided was reasonable under those circumstances. Next screen. Just a quick reminder on some new and increased obligations. Next screen. With regard to paid leave laws, the FFCRA may be a thing of the past, but certainly paid leave laws are on the rise. We saw a number of states and municipalities enact or enhance their paid leave laws in the last 12 months. Some of those were temporary, some of those were permanent, so make sure that you are paying attention to those that apply to you. And of course, we do, there's a good chance that there will be federal paid leave requirements under an FMLA type scenario under the Biden administration. Next screen. There is also a trend toward requirements for predictive scheduling obligations. The state of Oregon and a handful of cities have these type of requirements that make employers provide advance notice of an employee's schedule, usually for certain employers, and have fines for changing schedules. There's been no, those regulations don't account for unpredictable issues on the side of the employer, and of course COVID is the king of unpredictable. Some of those rules have been set aside or not enforced during the pandemic. Others of those locations have followed those regulations and enforced fines anyway. Next screen. Day of rest obligations is another trend that we're seeing. There are a few states that have some form of these type of obligations. They vary by state, of course, but essentially they require that workers have a 24-hour period of rest each week. These obligations, again, it's kind of a trend, but they can present real challenges to employers who have to cover unexpected absences due to COVID illness or quarantine. So that's another issue that will follow us into 2021. Next screen. We do have a new rule from the Department of Labor on independent contractor classification. This is the same as the proposed rule that came back out in September. It goes into effect March 8th. And the focus, it really is on whether a worker is economically dependent upon another business. If you read the rule itself, it's actually quite lengthy and recognizes the need for some additional clarity, the department recognized that the prior guidance had always been unclear and rather unwieldy. So it has set forth some factors to evaluate the economic realities. There is no safe harbor provision. We thought perhaps there would be, but it is not. Importantly, though, workers do not become employees simply because a company provides certain benefits. So that is a distinction. Next screen. Taking a look at the test itself, and if you read the rule, it does actually give some examples to help you further nuance through this. But the two key factors are the control over the work and the opportunity for profit or loss as a result of personal investment. So does the individual, because of the way they manage their operations, do they have an opportunity for profit or loss, or is that only at the hands of the employer who is holding the purse strings? Those are the two most important factors. If you can evaluate it based upon those two, the DOL says you don't have to go on to the remaining factors. If that's a close call or a split decision, then you look at the amount of skill required for the position, the permanence of that relationship. Is that contractor in and out for a particular job, or is this a long-term relationship? And also, how integrated is the worker's role to the organization's overall operation? Is it part of a department or a production scheme, or is it a one-time type of work that is performed? Next screen. Finally, we have a few predictions of what we expect in the Biden administration real quickly. Next screen. We do expect that there will be some changes to the overtime rule. The Trump Department of Labor finalized its own overtime rule in September of 2019 that increased the salary threshold to just over $35,000. That level is probably not going to satisfy a Biden DOL. Most likely they will want it to be at $47,000 or higher, and may also look to make changes in the duties test. So we'll be back to going through those steps we were in a few years ago to consider whether folks are properly classified and talk about how to change folks around. Certainly, we expect some immigration changes. The last time Democrats controlled the Senate, they passed comprehensive immigration reform, and Biden has vowed to take another crack at that. Probably will also revoke a number of Trump's executive actions. Topping those lists are probably those relating to refugees and asylees, certain COVID-19 related travel restrictions, and the ban on certain non-immigrant visas. Paid sick leave, again, we expect that there will be a charge to have some type of federally mandated paid sick leave. We expect that there will be some type of legislation with regard to pregnancy accommodation. A proposed House bill would clarify protections for pregnant workers under federal discrimination laws and would require employers to provide certain reasonable accommodations like more frequent restroom or water breaks to those employees. With regard to joint employer issues, that Trump DOL's joint employer regulation under the FLSA has been enjoined by a federal court, and the Biden DOL is expected to repeal and replace that rule with a broader and more amorphous joint employer standard for us to muddle through. And another piece of legislation that is predicted is the Protecting the Right to Organize Act that actually passed the House of Representatives in early 2020, and it would do a number of things with regard to union activities, such as prohibiting right to work laws, prohibiting employers from permanently replacing strikers, allowing for secondary boycotts, and a number of other items. So that takes me to the end of my presentation, and Matt, I will toss it back to you for some closing comments.
Thank you very much, Debbie. So we are a few minutes over the 2 o'clock hour, so I do apologize for running a few minutes over, but we wanted to make sure that we got all of the information today in front of you. Just as a reminder, we will be sending the slides and today's recorded session out to everyone within 1 to 2 business days, so please do keep an eye out for those materials to arrive in your email soon, and please don't hesitate to contact any of us if you do not receive them. We did have a number of questions that were posted in the questions box during the presentation today. We've made as good of an effort as possible to answer as many as we could, but for those that have not been answered, we will be reaching out to you individually via email after the presentation today. So then if you have any additional questions after we log off today, please do email Debbie Anthony or myself, or call your regular Thompson Hine lawyer. If you're not a current Thompson Hine client, please do feel free to contact one of us so we can discuss available options to address any needs that are impacting your business. So once again, I'd like to thank each and every one of you for attending today, and we hope that you enjoyed the material that we presented, and wish all of you a happy and healthy 2021. Thank you very much.